Hope you are doing well. Today in Law and Life, I, Sushant Mishra, will be interviewing on topic Agnipath agitation, challenges of protection of public property in age of limitless violence and agitation with senior advocate of Supreme Court of India, Subodh Markandeji. In the protest of which public property of Indian valued railway, conservatively valued at rupees 700 crore, have been destroyed in the act of erosion, rioting, vandalism during agitation against new procurement policy of armed forces of India called Agnipath. Why is there no law of or accountability?
There is no dearth of laws, but it seems to me that accountability, enforceability, and strategy have been conspicuous and definitely missing. Let us see the legal landscape. Uh, since 1976, that is 46 years, Article 51A, Clause I of the Constitution has been in existence. It casts a duty on every citizen to safeguard public property and abjure violence. There must be some way to enforce this duty against the erring citizens. The surest way, of course, is to promote responsible citizenship from the very childhood, where the child is studying, whether in elite English medium school or free government or municipal school or madrasas. All of them have a duty to impart the attributes of responsible citizenship. There is uh, there is no dearth of material also. Uh, in 1999, Justice J.S. Verma committee submitted a 425-page report in two volumes about the teaching of fundamental duties. That report was published by the central government and is available for all to be taught in every level of education. It has remained a dead letter since 1999. At present, the following are amongst others, are the laws as far as I know. Way back from 1860, Section 425 of the Indian Penal Code has been in existence. Now it defines mischief as involving guilty intent, that is mens rea, accompanied by acts resulting in destruction of property, for which punishment of 3 months imprisonment and fine is provided. In the next section, that is section 426, the effect of these provisions can hardly be deterrent. So, Prevention of Damage to Public Property Act was enacted in 1984. Briefly, this act defines in section 2 mischief to have the same meaning as section 425 of the Indian Penal Code. It also defines public property and makes uh, mischief to public property punishable with imprisonment from minimum 6 months to maximum 5 years. Then there is provision for more stringent punishment for aggravated form of offense of 1 year minimum imprisonment and maximum of 10 years plus fine. Recently, the Uttar Pradesh legislature has enacted the Uttar Pradesh Recovery of Damages to Public and Private Property Act in 2020.
My question is, what is the leading case on this topic, either brought up by prosecution or otherwise?
So, taking note of the inefficacy of the then existing law, the Supreme Court itself acted suo moto in a case called regarding destruction of public property versus Andhra Pradesh, state of Andhra Pradesh. I think it is reported in 2009, volume 5, SCC 212. The case was initiated by the Supreme Court itself in 2007 and it concluded in 2009. During the admission hearing, the Supreme Court appointed two committees, namely Justice K.T. Thomas Committee and Justice uh, F.S. Nariman Committee. Let us see the scope of these committees. So Justice K.T. Thomas Committee broadly had to examine and recommend appropriate amendments to the 1984 Act to give it more teeth. Then Fuzzy S. Nariman Committee had to evolve principles of assessment and payment of damages to victims of violence uh, and the role of media. There were two more significant cases also. That is, uh, that is one was Odun, Odunduluru Film Society versus Union of India, which is reported in 2018-10 SCC at page 713, and Mazdoor Kisan uh, Shahri Sangathan versus Union of India, also reported in 2018 in AIR 2018 SC 713.
Sir, how would you summarize the recommendation of Justice K.D. Thomas Committee and Fali Nariman Committee?
So, Justice Thomas Committee's main recommendations were to amend the 1984 Act so as to provide that there should be presumption about the guilt of the accused. Of course, a rebuttable presumption. Then it recommended that there should be prosecution of leaders of organization which called for direct action, which turned violent, for their abetment to the offences involved in the charge. Then they also recommended that videography should be conducted by the police in the event uh, any particular event turns violent. FS Nariman Committee's principal recommendations were that organizations who have organized the uh, event which turned violent must be held liable for destruction of and damage to public and private properties. And damages must be assessed and paid by such organizers. And there should be mechanism for such assessment and payment to the victims of violence. And about the media, the recommendations were that the media must act in the spirit of trusteeship, only to find truth and not to uh, incite anything. And then media must do self-regulation. So Supreme Court accepted these recommendations and gave directions accordingly. Thereafter, two more cases which I cited earlier uh, gave further supplementary directions.
What was the follow-up on Supreme Court judgment?
6 years have passed in, in the in 2015 when a bill to amend the 1984 Act on the lines suggested by the Supreme Court was prepared. But even after passage of 7 more years, it has not yet been enacted. A feeble attempt was made by the state of Punjab in 2017, but without any significant impact. Of course, as I said, recently the state of Uttar Pradesh in 2020 has no doubt enacted a more robust law.
So, having recent agitations against CAA and farms laws has been more strident and unmanageable, what is the current approach?
A way forward, in my humble view, is to bring a robust central law, assimilating therein all the principles laid down in the cases decided so far. The 2015 bill and the 2000 UP law, protection of public property from destruction and damage, and compensating the victims of violence were trapped there is too important a subject to brook any further delay.